to Module 4, we will now cover trademark law. So again, as a quick recap, we've now covered the basics for patents and copyrights, which are two components of our intellectual property type strategy. And now we're going to talk a little bit about trademarks. Now, in one of the last lectures for copyrights, we were doing a comparison between copyrights and patents, and there were some comparison as well to trademarks. But as you recall, the one-word summary that I had you think about was with respect to brands. So trademark really comes down to branding and how it is that occurs. Let's take a look at, for example, within the textbook, I'm on page 174. And the sections here come from the Lanham Act. And we'll discuss the Lanham Act a little bit more, but there's two questions that look a little bit at the societal type implications of trademarks that I want to raise. The first question is, Section A3D discusses confusion. And why does trademark law look at the likelihood of causing confusion? And I think one of the clearest examples of this could be to take an object that you would be very familiar with and look at it in a manner that wouldn't be. So for example, take a bottle of Coke. You see a bottle of Coke, you know that it's there. What happens if somebody mimics the exact shape, look of a bottle of Coca-Cola, but it's actually not Coca-Cola inside? So the integrity of the brand would be jeopardized. From one point of view, if there's competitors that are coming along, they're trying to mimic the shape, look, feel, things of that nature. So the integrity of the brand is compromised, and not only is the integrity of the brand compromised, but the confidence of the consumers in that brand is also compromised. So if the quality is not up to the standards that Coca-Cola would be otherwise be providing, then that, in the consumer's mind, may cause some hesitation as to, is this really the real thing or not? So when we talk about the confusion, the likelihood of causing confusion, it's from the point of view of the consumer. And if you have two products in front and one is the real and one's the counterfeit, the question is, to how closely does the counterfeit cause you to think that it is the real? The greater the line between them, then if there's little likelihood of confusion, that means that the integrity of the brand is maintained. But on the other hand, if that line gets closer and closer and closer together, where it's hard to distinguish the counterfeit from the real, then from the consumer's point of view, how do you really have confidence or trust in what you're buying if you're not sure that it's actually the real thing? This is actually evident even more so sometimes if you go outside of the states, where the counterfeit laws and the trademark laws may not necessarily be the same. So I've been in other countries before. There may be a bottle of Coca-Cola and you see it and you think that it's it, but it's only until you get really close and you look at the fine print that you realize it's actually not Coca-Cola. It's the same shape, the same look, and it almost tastes like the same thing, but the reality is that it is not the same thing. And if it's not the same thing, then in the consumer's mind, they immediately may think, ooh, well, if it's not the real thing, what is it? And it's that confusion that we are trying to avoid. Because the greater the confusion in what you're buying, the greater the confusion in what you think is the real thing, leads to less integrity in the connection between the consumer's confidence and the actual brand of what it is they are looking at. Trademark law is all about maintaining this integrity of the brand. The greater the integrity, the greater the confidence, the more people will trust what it is that they actually buy. The second question here, Section B, discusses a bona fide intention. The question that I wanted to pose to you is, what would happen to society if this bona fide intention was not a requirement? So let's say that you come up with a name, Lucky Jeans. Actually, there is a Lucky Jeans. Let's say it's Lucky Banana. And that is the name of your company. And let's say that you do not even have any intention of creating a product or selling a product. It's simply a name that you think this will be catchy, it will be good, people will like it. If you have absolutely no intention of actually even using it. If you apply and let's say are granted trademark rights, very quickly you can see that if millions of people are doing this, people in essence are getting rights to a name, and it essentially ties up the entire market. So it's one thing to say, for example, for patents, you can get an invention that may be years of work and years of effort, but even at the end of the day, if you choose not to actually create the invention, you can still have rights to it. And that's kind of a reflection of your own hard work and grit and effort in getting to the end goal. And the reward is you can still have rights even if you don't even produce it. But for trademarks, the fundamental reason why we have trademarks is, again, this idea of having consumer confidence and brand integrity. And if there is no reason and no intention to even build this brand, then what's the point of even having confidence in a brand that doesn't exist? It just doesn't work. So this bona fide intention, one, maintains that when there actually is a brand that is coming out, that is being built, that we want to establish this consumer confidence in it. And so anyway, so what would happen to society if that did not exist? Well, what would happen is that you would have all these brands that exist that are not being used, which almost would negate the whole reason why it is you have trademark law, to build this relationship between consumer confidence and a brand that is actually either selling something or maintaining or even providing a service. So in other words, it would not be as much of a benefit to society. Let's talk about trademarks now. Now there's two, when we talk about trademarks, we'll talk about why it is that there is even a need for trademark, and we've actually kind of already discussed that a little bit with respect to my questions. We'll look at the statutory basis as far as the Lanham Act is concerned. We'll look at the categories of marks. So there's a few different types of marks that you can actually get protection for. Trademarks are usually for trade goods. Service marks, as we will discuss, are actually over services, in case you're not aware. We'll look at the different standards of protection, and it's really is kind of on this complete scale of very strong protection to less protection, and where it is that names, logos, marks, things of that nature actually fall on this scale. We will look at obtaining protection, loss of protection, and actually enforcement. So as an introduction, let's talk about, one, this is looking a little bit at the introduction and history of trademarks, but I think it does a good job as far as framing the context for our discussion.
What qualifies for trademark protection? Any recognizable word, phrase, name, symbol, design, or device can qualify for trademark protection. Although these seem like very broad categories, the USPTO has defined and differentiated these in interesting and surprising ways. There is little confusion about what is meant by a trademark-eligible word, phrase, or name. To be eligible for trademark, a word, name, or phrase must be distinctive, and it must indicate the origin of a product or service. When are symbols and devices eligible? The language of the Lanham Act, the federal statute governing trademark use, does not specify what constitutes a symbol or a device that can be trademarked. The U.S. Supreme Court took careful note of that fact, ruling in 1995 that, since human beings might use as a symbol or device almost anything at all that is capable of carrying meaning, this language, read literally, is not restrictive. In the United States, therefore, trademarks can include almost anything that carries distinctive meaning and identifies the origin of products and services. This includes slogans, letters, numbers, logos, three-dimensional designs, even colors, scents, and sounds that indicate the source of a good or service to consumers. The number 5, for example, is a trademark symbol of Chanel No. 5 perfume. so is the number 31, which is the trademark symbol of Baskin-Robbins 31 flavors. No trademark can block the use of the numbers 5 or 31 in math, nor have the courts allowed the trademarking of mere part numbers, model numbers, or grades, because these are not distinctive enough and do not indicate the origin of the goods in question. Regular gas, also known as 87 octane, also cannot be trademarked because it doesn't tell you whether the gas comes from Exxon, Shell, or BP. When are scents eligible? The fundamental case for determining the trademark eligibility of a scent came about when the USPTO denied Celia Clark's 1990 request for a trademark on yarns and threads with a fresh, floral fragrance reminiscent of plumeria blossoms. She appealed, and the Trademark Trial and Appeal Board overruled the examiner, granting her a trademark for the scent. However, a trademark cannot be granted for any scent that serves a function other than identifying the product's source. The scent of perfumes and air fresheners, therefore, cannot be registered. There remains a good deal of uncertainty around the trademark eligibility of scents. When are sounds eligible? Sounds can also be trademarked provided they indicate the source of the product or service with which they are associated, and, indeed, there are approximately 700 trademarked sounds registered at the USPTO. These include Tarzan's Yell, AOL's You've Got Mail announcement, and the sound of a duck quacking Aflac for the American Family Life Assurance Company. When are designs eligible? A design, like a logo, can also be trademarked, provided it distinguishes the origin of the product or service. In these trademarks, the logo must be unique and consist of more than simple stylization. Examples of pure trademark designs without any associated words include Nike swoosh and Apple's famous logo of a bitten apple. However, design trademarks typically take a design plus words approach, as with the trademarked Lacoste logo, featuring the word Lacoste below the famous green alligator. What is trade dress? Trade dress refers to the overall appearance of a product or service that indicates its source. Trade dress can include size, shape, color, texture, graphics, or even particular sales techniques. The key to claiming trade dress protection is that the attributes must be distinctive. For example, Taco Cabana has trademarked its distinctive and festive eating atmosphere, having interior dining and patio areas decorated with artifacts, bright colors, paintings, and murals, and won an infringement case against a competitor restaurant called 2 Pesos. How do design trademarks and trade dress differ from design patents? Design trademarks and trade dress are different from design patents. Although all three cover only non-functional designs and appearances, design patents strictly protect only the new and original ornamental design of an article of manufacture, and the actual drawing of a design patent limits what is protected. A design trademark, on the other hand, protects a word, name, symbol, or design used in commerce to distinguish a product's source. Trade dress protects the overall appearance of the product and can include anything that gives a product or service meaning and distinguishes it from those of any other producer. A design patent might protect the new and original ornamental design of a lamp, for example, so long as that appearance does not affect the lamp's function. A design trademark would protect the words or symbols used on the lamp that identify it as coming from a particular producer. Trade dress protects the look and feel of the lamp. Sometimes both forms of protection can be obtained. Examples of products with both design trademarks and design patents include the Dustbuster vacuum cleaner, the Pepsi bottle, and the Honeywell round thermostat.
So I like this video, and one of the reasons why is when we had our discussion before as far as the one-word summary that I wanted you to come up with, one of the things that I asked you to keep in mind was with respect to, for example, the one-word type summary. And I indicated to you that for me, I think of brands when I think of trademarks. But in viewing this video, one other one-word summary that you may be coming up with, or that you may be thinking, and that they actually mentioned several times in that video, was source. The source of a good, that the source of a product, that the source of what is being sold can actually be known. And that would, I think, be an equally good or to distinguish how does the trademarks differ than, for example, copyrights and or patents. So trademarks, when we think about this, building brand protection, brand integrity, and also from the consumer point of view, we understand the source of where something is actually coming from. Let's briefly talk about the need for trademarks. So we talked about what would happen potentially if there were not limits, for example, on that bona fide intent. We also talked about the likelihood of confusion that may result. That is also a fundamental basis for trademarks. But again, this idea is keeping the communication line open and clear between the buyer and the seller. Again, open, clear communication line between the buyer and the seller. So in that open communication line, there is immense value, a value of reputation, value of a name, value of a brand. All this value really goes into building this communication channel between buyers and sellers. The value of the experience of that reputation, the value of the experience of the name or brand. So for example, sometimes an individual may buy a particular pair of jeans, not necessarily because it's known as the best one out there, but because you have this particular confidence in the brand in which you are buying. Now, if trademarks did not exist, buying would be a lot more difficult. What does a brand actually mean? Does this brand, is there some minimum integrity level to make sure that it's up to a certain quality? If trademark law did not exist, it would be much more hard, it would be a lot more hard to actually figure out whether or not what you're buying is indeed from the source that you think you're buying from. Not only that, but let's assume that we have one brand that's being built up, that's having some success. What would prevent somebody else from essentially piggybacking on the success of one brand by adopting their logo, the use, and everything associated with the brand is succeeding? So it would very much encourage free riders to come along to mimic those that are having success. So in short, trademark law forbids anything that one would sever or put into question this communication line between the buyers and sellers. That's one aspect. And the other is to really ensure that when a brand emerges, that it has protections in place to ensure the free riders do not come along to essentially misappropriate what is not theirs. So trademarks, brands, source, and what does it prevent? Confusion, deception. So that's a very kind of at a high level why it is that we have trademarks. So the Lanham Act was passed in 1946. Keep in mind that even prior to that time, there was actually a lot of dispute about trademarks even within the US. For example, trademarks is not covered in the Constitution. And so for a period in the US, there was a number of judges that actually saw a need to have trademarks within the US, and so they started to make some laws relating to it. And then some Supreme Court justices came down and said, well, actually, trademark law is not covered by the Constitution, therefore what you're doing is unconstitutional. So there were several different revisions where Congress actually came together early 1900s, actually even slightly before that time frame, and there was a series of laws that they passed to assist with protecting this concept of trademark law. The Lanham Act, passed in 1946, is the most substantive version of all those iterations of the laws that actually contributed to the trademark. Lanham Act globally relates to trademark, but in particular what it actually discusses is one, trademark infringement. What is the liability based off of, for example, the confusion of the goods or the services? Talks about dilution, false designation of goods, false advertising, interesting, and even anti-cyber squatting. So it relates to trademarks, and I would indicate peripheral concepts that also would be associated with associating a name with some source. So even, for example, websites would be a name that you presume is a source associated with that name as well.